Rule 7. Parts of a pleading. What are the parts of a pleading? We use SBCA. The parts of a pleading are the following. C. Caption. This sets forth the name of the court, the title of the action, and the docket number if assigned. B. The body of a pleading sets forth its designation, the allegations of the party's claim or defenses, the relief prayed for, and the date of the pleading. 3. S. Signature and address. Must include also the matter stated in answer to the next question. Q. What matters or information should be stated by counsel below his signature? We can use the word firma. P, or number 1, his address, which should not be a post office box. Not be a post office box. His PTR official receipt number for the current year. Number 3, his IBP official receipt number for the current year. Number 4, his roll number. And number 5, number and date of issue of MCLE Certificate of Compliance or Certificate of Exemption for the current or immediately preceding compliance period, based on Supreme Court resolution dated 17 February 2015. And finally, in papers and pleadings filed with the SC, the counsel should indicate his contact details. Example, phone number, fax number, cell phone number, or email address. Q. What is the effect if the counsel fails to state below his signature numbers 1 to 4 above? The pleading is considered as not having been signed. What is the effect if the counsel fails to indicate in his pleading the number and date of issuance of his MCLE Certificate of Compliance or Certificate of Exemption for the current or immediately preceding compliance period? Failure to disclose the required MCLE information pursuant to Supreme Court resolution dated February 17, 2015 would subject the counsel to appropriate penalty and disciplinary action, but would no longer cause the dismissal of the case and the expunction of the pleadings from the records. The non-compliant lawyer shall be discharged from the case, and the client shall be allowed to secure the services of a new counsel with the concomitant right to demand the return of fees already paid to the non-compliant lawyer. Q. Is a prosecutor required to indicate in the information the number and date of issue of his MCLE compliance certificate? May the court dismiss the information in case of failure to do so? Yes, the prosecutor is required to do so since an information is a pleading. Nonetheless, the court should not dismiss the information, but simply require the investigating prosecutor to indicate the required information. Sample, People versus Arujado, 9 November 2005. Q. Give the rules regarding the inclusion of the party's name in the pleadings. Number 1. The names of all the parties should be included in the original complaint. In subsequent pleadings, it is sufficient if the name of the first party on each side be stated with an appropriate indication when there are other parties, such as by using the word et al. Section 7. Section 1, Rule 7. The names of all the parties in an appeal shall also be indicated in the notice of appeal and record on the appeal. Section 5 and 6 of Rule 41. Number 2, in a class suit, it is sufficient if the names of those appearing in the complaint as plaintiff or in the answer as defendants be sufficiently numerous and representative as to fully protect the interest of all concerned. Section 12, Rule 3. Number 3, whenever the identity or name of defendant is unknown, he may be sued as the unknown owner, heir, devisee, or by such other designation as the case may require. When his identity or true name is discovered, the pleading must be amended accordingly. Section 14, Rule 3. Number 4, when 2 or more persons not organized as an entity with juridical personality enter into a transaction, they may be sued under the name by which they are generally or commonly known. In the answer of such defendant, the names and addresses of the persons composing such entity must all be revealed. Section 15, Rule 3. Q. May a court adjudge a defendant liable for 1 million where the specific amount prayed for in the complaint is only 800 and there is no general prayer for such further or other relief as may be deemed just or equitable? Yes, provided the evidence so warrants and the defendant fails to object to the introduction of evidence on the additional 200,000. In such a case, the plaintiff shall pay the additional filing fee on the 200,000 which shall constitute a lien on the judgment award. Section 5, Rule 10, Section 2, Rule 141. Note, however, that a judgment rendered against a party in default cannot exceed the amount nor be different in kind than that prayed for. Section 3, letter D of Rule 9. Q. May the court in its final judgment award a claim not alleged or a relief different from or more than that claimed in the pleading? The answer is yes, Section 2, Rule 141. Of course, the evidence on record should so warrant, and the provisions of Section 5, Rule 10 should be taken into account. The docket fees on such award shall constitute a lien on the judgment. Section 2, Rule 141. Q. What is the rule regarding the signing of pleadings? Every pleading and other written submission to the court must be signed by the party or counsel representing him. Section 3, Rule 7. Q. The OSG, in behalf of the Republic, filed a complaint in the RTC for the revocation of titles registered in the name of Kenrick Development Corporation or KDC. KDC filed an answer which was purportedly signed by its counsel, Attorney G. The trial of the case was held up by various pre-trial and discovery issues. 2 years later, Attorney G, who by then was no longer KDC's counsel, was summoned in a congressional hearing on fake land titles. He testified that he prepared KDC's answer and sent an unsigned draft to KDC's president. He testified that the signature appearing above his name in the answer was not his, and that he did not authorize anyone to sign in his behalf, and he did not know who signed above his name. The Republic filed a motion to declare KDC in default and failure to file a valid answer. The RTC granted the motion, declared KDC in default, and allowed the Republic to present its evidence ex parte. On appeal, the CIA reversed the RTC, saying that Attorney G assented to the filing of the answer in his behalf as he never disowned the answer and resumed acting as counsel for KDC after its filing. Did the CA err? Yes. Section 3, Rule 7 is quite clear when it requires that a pleading must be signed by the party or counsel representing him. Hence, only the signature of either the party or himself, his counsel, operates to validly convert a pleading from one that is unsigned to one that is signed. Counsel's authority to sign a pleading is personal to him and may be delegated only to another lawyer pursuant to Rule 901 of the Code of Professional Responsibility. Hence, Attorney G's blanket authority, whether express or implied for just anyone to sign, was void. The answer being unsigned, it produced no legal effect, and thus Republic versus Kenrick Development Corporation KDC was properly declared in default. GR 149576, August of 2006. Note, the court in its discretion may allow the defect of an unsigned pleading to be remedied if the failure to sign was inadvertent and not intended to delay. Here it appears that the filing of that spuriously signed answer was not inadvertent. Q. What is the significance of counsel's signature on a pleading? The signature of counsel constitutes a certificate by him that he has read the pleading and document that, to the best of his knowledge, information and belief formed after an inquiry reasonable under the circumstances. Number 1, it is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Number 2, the claims, defenses, and other legal contentions are warranted by existing law or jurisprudence, or by a non-frivolous argument for extending, modifying, or reversing existing jurisprudence. The factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after availment of the modes of discovery under these rules. And 4. The denials of factual contentions are warranted on the evidence or, if specifically so identified, are reasonable based on belief or lack of information. Section 3, letter B, Rule 7, as amended by the 2020 Rules on Civil Procedure. Q. What is the consequence if there is a violation of Section 3, letter B of Rule 7? If the court determines on motion or motu proprio and after notice and hearing that this rule has been violated, it may impose an appropriate sanction or refer such violation to the proper office for disciplinary action or on any attorney law firm or party that violated the rule or is responsible for the violation. Absent exceptional circumstances, a law firm shall be held jointly and severally liable for a violation committed by its partner, associate, or employee. The sanction may include but not limited to non-monetary directives or sanctions, an order to pay a penalty in court, or if imposed on motion and warranted for effective deterrence, an order directing payment to the movant of part or all of the reasonable attorney's fees and other expenses directly resulting from the violation, including attorney's fees for the filing of motion for sanction. The lawyer or law firm cannot pass on the monetary penalty to the client. Is it required that a pleading be under oath, verified, or accompanied by affidavit? Answer: except when otherwise specifically required by law or rule, pleadings not need be under oath, verified, or accompanied by affidavit. Rule 7, Section 4. How is a pleading verified? A pleading is verified by an affidavit of an affiant duly authorized to sign said verification. The authorization of the affiant or affiant to act on behalf of a party, whether in the form of a secretary's certificate or a special power of attorney, should be attached to the pleading and shall allege the following attestations. 1. The allegation in the pleading are true and correct based on his personal knowledge or based on authentic documents. B. The pleading is not filed to harass, cause unnecessary delay, or needlessly increase the cost of litigation. And finally, the factual allegations therein have evidentiary support or, if specifically so identified, will likewise have evidentiary support after a reasonable opportunity for discovery. The signature of the affiant shall further serve as a certification of the truthfulness of the allegations in the pleading. Section 4, Rule 7, 2020 Rules of Civil Procedure. Who may make a verification? A verification may be made by the party, his lawyer, or his representative, or any person who personally knows the truth of the facts alleged in the pleading. Tanwatko versus Judge Gakko. RTJ 06-2006, March 23, 2009. If made by a person other than the party, such person's authority to sign the verification, whether in the form of a secretary's certificate or special power of attorney, should be attached to the pleading. Section 4, Rule 7. What would be the effect if a pleading required to be verified is not verified or lacks a proper verification? A pleading required to be verified which is not verified or lacks a proper verification, as in those containing a verification based on information and belief or upon knowledge, information, and belief, shall be treated as an unsigned pleading. Section 4, Rule 7. An unsigned pleading produces no legal effect. However, the court may, in its discretion, allow such deficiency to be remedied if it shall appear that the same was due to mere inadvertence and not intent for delay. In practice, the Supreme Court has been strict with the requirement for verification in petitions filed before it. What pleadings or papers are required to be verified? The following pleadings or papers are required to be verified. 1. Petition for relief from judgment. Section 3, Rule 38. Petition for review on certiorari. Section 1, Rule 45. Petition for review from the Regional Trial Court to the Court of Appeals. Section 1, Rule 42. Appeal from quasi-judicial bodies to the Court of Appeals. Section 5, Rule 43. Petition for annulment of judgment of the Regional Trial Court. Section 4, Rule 47. Petition for review of judgment of the Commission on Audit and the Commission on Elections. Section 5, Rule 64. Complaint with application for preliminary injunction or temporary restraining order. Section 4, Rule 58. Complaint with application for appointment of receiver. Section 1, Rule 59. Complaint with application for support pendente lite. Section 1, Rule 61. Petition for certiorari, prohibition or mandamus. Rule 65. Petition for quo warranto. Section 1, Rule 66. Complaint for expropriation. Section 1, Rule 67. Complaint for forcible entry and unlawful detainer. Section 1, Rule 70. Complaint, compulsory, counterclaim, cross-claim, and the answers thereto under the Rule on Summary Procedure. Section 3, Letter B, Rule on Summary Procedure. Petition for appointment of a general guardian. Section 2, Rule 93. Petition for leave to sell or encumber property of an estate by a guardian. Section 1, Rule 95. Petition for the declaration of competency of a ward. Section 1, Rule 97. Petition for habeas corpus. Section 3, Rule 102. Petition for writ of amparo and writ of habeas data. Rule on the writ of amparo. Section 6, Rule on the writ of habeas data. Petition for cancellation or correction of entries in the civil registry. Rule 108, Section 1. Petition to take deposition in perpetuam re memoriam. Rule 24, Section 1. Petitions governed by summary judicial proceedings under the Family Code, Articles 223, 225, 235, 239, 249, and 253 of the Family Code. Suit between members of the same family, Article 151, Family Code. Petition for declaration of nullity or annulment of marriage or for legal separation. Section 2, Letter B, Number 3 of the Supreme Court Rule on Legal Separation. Section 5, Supreme Court Rule on Declaration of Absolute Nullity of Marriage and Annulment of Voidable Marriage. And Number 25, Statement of Claims and Response in Small Claims Cases. Certification against forum shopping. What is forum shopping? The act of a party who, as a result of an adverse opinion in one forum, seeks a favorable opinion other than by appeal or certiorari in another, or who institutes two or more actions or proceedings grounded on the same cause, on the same gamble, that one or the other court would make a favorable disposition. City of Cebu versus Del Rosario, GR number 169341. Why is forum shopping prohibited? Forum shopping is prohibited because of the vexation caused the court and parties litigants by a party who asks different courts or administrative agencies to rule on the same or related causes or to grant the same or substantially the same relief, in the process creating the possibility of conflicting decisions being rendered by the different fora upon the same issues. Municipality of Taguig versus Court of Appeals. SCRA 469588. What is the best or the test for determining whether a party violates the rule against forum shopping? The test for determining whether a party violates the rule against forum shopping is to ask whether a final judgment in one case will amount to res judicata in the action under consideration, or whether the elements of litis pendentia are present. If the answer is yes, there is forum shopping. Marcoper Mining Corporation versus Solid Bank. X was driving a dump truck of Y along Catlea Street in Santa Maria, Bulacan. Due to his negligence, X hit and injured B, who was crossing the street. Lawyer L who witnessed the incident, offered his legal services to V. V, who suffered physical injuries including a fractured wrist bone, underwent surgery to screw a metal plate to his wrist bone. On complaint of V, a criminal case for reckless imprudence resulting in serious physical injuries was filed against X before the Municipal Trial Court of Santa Maria. Attorney L, the private prosecutor, did not reserve the filing of a separate civil action. V subsequently filed a complaint for damages against X and Y before the Regional Trial Court of Pangasinan in Ordaneta, where he resides. In his certification against forum shopping, V made no mention of the pendency of the criminal case in Santa Maria. Is V guilty of forum shopping? V is not guilty of forum shopping. The Supreme Court has held that the test to determine whether there is forum shopping is whether the second action may be barred by res judicata or lis pendens. Here, the second action is one for physical injuries and is thus an independent civil action separate and distinct from and which shall proceed independently of the criminal action for reckless imprudence, Article 33 Civil Code, Rule 111, Section 3. Hence, there is no res judicata or lis pendens and thus no forum shopping. What is a certification against forum shopping? It is a certification under oath by the plaintiff or principal party in the complaint or other initiatory pleading asserting a claim for relief, or in a sworn certification annexed thereto and simultaneously filed therewith, stating that he has not theretofore commenced any action or filed any claim involving the same issues in any court, tribunal, or quasi-judicial agency. To the best of his knowledge, no such other action or claim is pending therein. If there is such other pending action or claim, a complete statement of the present status thereof, and if he should thereafter learn that the same or similar action or claim has been filed or is pending, he shall report that fact within 5 days therefrom to the court wherein his aforesaid complaint or initiatory pleading has been filed. We use CPR. The authorization of the affiant to act on behalf of a party, whether in the form of a secretary's certificate or a special power of attorney, should be attached to the pleading. P filed a complaint against D for collection of sum of money. No certification against forum shopping was contained or annexed to the complaint. D filed a motion to dismiss the complaint on the ground of failure to comply with Section 5, Rule 7. P filed an amended complaint to which is now annexed the certification against forum shopping. Should D's motion to dismiss be granted? Still yes. Failure to comply with the requirements under the first paragraph of Section 5, Rule 7 shall be cause for the dismissal of the complaint without prejudice unless otherwise provided. The failure to comply with the requirements of Section 5, Rule 7, the filing of a certification against forum shopping, shall not be curable by mere amendment of the complaint or other initiatory pleading. If P's complaint is dismissed, what is the remedy or recourse available to P? P has two options which he can consider. P may simply refile the complaint and annex thereto the certification against forum shopping. This is because the dismissal for failure to comply with the requirements of annexing a sworn certification against forum shopping is a dismissal without prejudice. P may also file a special civil action for certiorari in order to set aside the dismissal order if P feels that the order was made with grave abuse of discretion amounting to lack or excess of jurisdiction. Appeal is not available to P as an appeal may not be taken from an order dismissing an action without prejudice. Q. Is the submission of false certification against forum shopping a ground for summary dismissal with prejudice? No. Violation of Section 5, Rule 7, other than through willful and deliberate forum shopping, does not authorize the court to dismiss a case without motion and hearing. Even if the submission of a false certification of non-forum shopping does not automatically warrant dismissal of the case, even if it might constitute contempt of court. De Leon versus Chu. There must be motion and hearing. When would the dismissal for the violation of Section 5, Rule 7 be with prejudice? If the dismissal order so provides, or if the acts of the party or his counsel clearly constitute willful and deliberate forum shopping. Juan filed with the Makati RTC a petition for custody against his wife, Michelle, praying for joint custody or visitation rights over his two daughters, then in the custody of Michelle. Michelle filed her motion to admit answer with motion for issuance of protection order. The Makati RTC denied Michelle's motion to admit answer. Subsequently, Michelle withdrew her motion for issuance of protection order. Michelle then filed with the Muntinlupa RTC a petition for temporary and permanent protection order under the provisions of RA 9262. One argues that the Muntinlupa case should be dismissed on the ground of forum shopping. Michelle counters that she cannot be guilty of forum shopping since she was the respondent in the Makati case. Is Michelle guilty of forum shopping? The answer is yes. The fact that Michelle was not the plaintiff or petitioner in the first case does not detract from the charge of forum shopping if she asked for the same relief in both cases. In both cases, she asked for the same relief of a protection order. Hence, the second case should be dismissed on the ground of forum shopping and or list pendants. While there was a withdrawal by Michelle of her motion for protection order in the Makati case, it should be noted that such withdrawal was made after her motion was in effect denied by the Makati RTC. This clearly smacks of forum shopping. Brown Araneta versus Araneta, October 9, 2013. A petition for review was filed with the Court of Appeals. The verification and CFS attached thereto, however, lacked the notarial seal, although the notary's public signature and stamp were present. Shall this be a cause for the dismissal of the petition? The answer is no. The verification and certificate against forum shopping were in fact submitted. An examination of these documents show that the notari's public signature and stamp were duly affixed, except for the notarial seal. All the requirements for the verification and certification documents were complied with. Hence, there was substantial compliance with the requirements on the verification and certification against forum shopping. Regulus Development versus De La Cruz. Petitioners are husband and wife. They filed a petition for certiorari and mandamus before the Court of Appeals, but only the husband signed the certification against forum shopping. Is the husband's signature sufficient? The answer is yes. The husband's signature alone is sufficient compliance with the rule on certification against forum shopping. Spouses Dar versus Alonso Legasto. May counsel be a party May counsel for a party sign CFS or certification against forum shopping? As a general rule, no. The certification form or the certification against forum shopping needs to be signed by the party himself, since he is the best position or he is in the best position to state the matters therein. Exception would be the case wherein the party is a juridical person, in which case the lawyer could sign. The lawyer must, however, be specifically authorized by a board resolution. BPR Leasing Corporation versus CA. If for reasonable or justifiable reasons the party pleader is unable to sign, he must execute a special power of attorney designating his counsel of record to sign on his behalf. Jacinto versus Gumaru, June 2, 2014. May an attorney, in fact, who was authorized to prosecute a suit on behalf of the principal sign the CFS in behalf of the principal? As a general rule, no. The reason is that it is the party himself who is in the best position to state the matters required in the CFS, particularly whether actions or claims involving the same issues have been filed or are pending. However, for justifiable reasons, the attorney, in fact, may be the one to sign the CFS, as for instance, where the attorney, in fact, is himself a party to the case and shares a common interest with the other parties. Bandilion versus La Filipina, Uy Ngoy Co Corporation. Or where the party is not residing in the Philippines, We versus Galvez, August 11, 2004. Respondent, a resident of the United States, executed an SPA appointing her daughter, Grace Galvez, to act as her attorney in fact in the Philippines. The special power of attorney authorizes Grace Galvez to do the following: to ask, demand, and claim any sum of money that is duly or due from any person, natural, juridical, or corporation in the Philippines, to file criminal or civil complaints before the courts of justice in the Philippines to enforce my rights and interests, to attend hearings and or preliminary conferences to make stipulations, adjust claims to settle, or enter into compromise agreements to litigate and to terminate such proceedings, and to sign all papers, documents, and pleadings necessary for the accomplishment of the above purposes. Is this sufficient authority for Grace Galvez to sign the CFS in behalf of the respondent? The answer is yes. Grace Galvez's attorney, in fact, of the respondent was duly authorized and empowered not just to initiate complaints, whether criminal or civil, to enforce and protect the respondent's rights, claims, and interests in this jurisdiction, but is specifically authorized to sign all papers, documents, and pleadings necessary connected with the filing of a complaint. The aforementioned papers and documents which Grace Galvez was authorized and empowered to sign must necessarily include the CFS. We versus Galvez. RTC filed a complaint for the annulment of foreclosure sale against Bank B. In its answer, Bank B set up a counterclaim for actual damages and litigation expenses. RC filed a motion to dismiss the counterclaim on the ground that Bank B's answer with counterclaim was not accompanied by certification against firm shopping. I would rule on the denial of the motion to dismiss. The Supreme Court has held that a certification against firm shopping is not required for asserting a compulsory counterclaim, since it is not an initiatory pleading or incipient application but merely auxiliary to the main proceeding. Espouses Ponciano versus Parentela, May 9, 2000. Here, the counterclaim is for actual damages and litigation expenses and thus compulsory since it arose out of the transaction or occurrence which is the subject matter of the RC's complaint. Hence, the motion to dismiss should be denied. The NLRC rendered the decision against Father Tabora, the Ateneo de Naga University, and Edwin Bernal, the petitioners. The petitioners filed a petition under Rule 65 seeking the reversal of the NLRC decision. The verification and the certification against firm shopping was, however, signed only by Father Tabora. The SIA dismissed the petition insofar as the Ateneo and Bernal were concerned, notwithstanding a belated showing that Father Tabora had been authorized to sign the verification and certification for the Ateneo and Bernal. Was the dismissal proper? The answer is no. In verification, the signature of one instead of all the parties would be sufficient if there is showing that he had sufficient knowledge and belief to sign the verification. As regards the CFS requirement, there was substantial compliance with the submission, albeit delayed, of proof that Father Tabora had been authorized to sign the CFS for the Ateneo and Bernal. The Supreme Court considered the delay a mere technicality or procedural imperfection which should not defeat the ends of justice. Ateneo de Naga University versus Manalo. The verification and certification against firm shopping appended to the appeal to the NLRC were signed by BPI's Assistant Vice President. There was no proof, however, that the AVP was authorized by the Corporation Board. Are the verification and the certification against firm shopping fatally defective? No. The AF or the AVP as a corporate officer has implied or apparent authority to sign the verification and certification. An express authorization is not an indispensable requirement. The fact that BPI acquiesced and expressed no objection to the appeal by before the NLRC is proof that it authorized the AVP to sign the verification and the certification. Enriquez versus BPI, GR 172812. Who are corporate officers or employees who may sign the verification and certification against firm shopping without need of a board resolution? 1. Chairperson of the Board of Directors, 2. The President, 3. General Manager or Acting General Manager, 4. Personnel Officer, and 5. Employment Specialist in a labor case. The rationale for this list is that these officers are in a position to verify the truth and correctness of the allegations in the complaint or petition. Cagayan Valley Drug Corporation versus Commissioner of Internal Revenue, GR 151413. The vice president and assistant vice president may be added to the list. Korean Airline or KAL, a foreign corporation licensed to do business in the Philippines, filed a collection case against Expert Travel and Tours. The verification and certification was signed by its counsel and resident agent X. To the motion to dismiss filed by Eti KAL, counter that X was authorized by KAL in a teleconference by the board of directors. No record of such authorization was attached to the complaint. Can the resident agent sign the verification NCFS in behalf of a foreign corporation? The answer is no. X was not specifically authorized to execute the certification in behalf of KAL. Being a resident agent does not mean that he is authorized to execute the requisite CFS because while he may be aware of the actions filed against his principal, he may not be aware of actions initiated by his principal, whether in the Philippines or in the country where such foreign corporation is organized. Expert Travel and Tours versus CA. The notarial certificate of the certification of non-form shopping attached to private respondent's petition before the CA did not state whether they presented competent evidence of their identities or that they were personally known to the notary public. Should the petition be dismissed? The answer is yes. Under Section 6, Rule 2 of AM number 02813, Supreme Court dated July 6, 2004, entitled 2004 Rules on Notarial Practice. A jurat refers to an act in which an individual on a single occasion appears before the notary public and is personally known to the notary public or identified by the notary public through competent evidence of identity as defined by the rules. Hence, the verification and certification are fatally defective to failure to comply with the said rules. William Go Q Construction versus Sing Song. In the proceedings for a settlement of the estate of Alice, a contingent money claim for commission in the event of the sale of properties of the estate was filed by Alan with the probate court. The executrix moved for the dismissal of the claim on the ground that no certification against form shopping was attached thereto, pursuant to Section 5, Rule 7. The RTC dismissed the money claim. Was the dismissal proper? No. A certification against form shopping is required only for complaints and other initiatory pleadings. A money claim against the state is not an initiatory pleading, since the probate proceeding was already initiated upon the filing of the petition for the allowance of the decedent's will. A money claim does not initiate new litigation but merely brings a material but incidental matter arising in the progress of a case. Hence, a money claim is only incidental to the probate proceeding, more so if it is contingent, since the claimant cannot even institute a separate action for a mere contingent claim. Shecker versus State of Shecker. GR 157912. Metrobank extrajudicially foreclosed on a real estate mortgage and purchased the realty at the auction sale. Since the mortgager refused to vacate the realty, Metrobank filed an ex parte petition for writ of possession over the foreclosed property. Pursuant to Act Number 3135, the mortgager, who was allowed by the court to intervene, filed a motion to dismiss the petition on the ground that a false certification against form shopping was attached, since it did not disclose cases filed by the mortgager involving the same parties and the loan agreement secured by the mortgage. Should the motion to dismiss be granted? Or B, if the motion to dismiss is granted, what is the remedy of Metrobank? Answer to letter A, no. While denominated as a petition for writ of possession, it is not an initiatory pleading, since under Section 7 of Act 3135, such petition is filed in the form of an ex parte motion. In other words, the petition for writ of possession is in substance merely a motion. Hence, dismissal of the petition on the ground of submission of a false CFS is unwarranted, since in the first place, a certification against form shopping is not even required. Metrobank versus Abad Santos, December 15 of 2009. Letter B. The remedy of Metrobank is to file with the Court of Appeals a special civil action for certiorari unless a dismissal provided that it is with prejudice. Appeal is not available since a dismissal for failure to comply with Section 5, Rule 7 is without prejudice and thus it is certiorari under Rule 65, which should be availed of. If the dismissal provided that it is with prejudice, then appeal would be proper. Does a petition for writ of possession in favor of the buyer in local tax delinquency sale require a certification against firm shopping? The answer is no, since such petition, again, is not an initiatory pleading. Give a capsule form the jurisprudential pronouncements respecting noncompliance with the requirements on or submission of defective verification and certification. Capsule form. Number one, a distinction must be made between non-compliance with the requirement on or submission of defective verification and non-compliance with the requirement on or submission of defective compliance against firm shopping. As to verification, non-compliance therewith or a defect therein does not necessarily render the pleading fatally defective. The court may order its submission or correction or act on the pleading if the attending circumstances are such that strict compliance with the rule may be dispensed with in order that the ends of justice may be served thereby. Verification is deemed substantially complied with when one who has ample knowledge to swear to the truth of the allegation in the complaint or petition signs the verification and when matters alleged in the petition have been made in good faith or are true and correct. Number four, as to certification against firm shopping, non-compliance therewith or a defect therein, unlike in verification, is generally not curable by a subsequent submission or correction thereof unless there is a need to relax the rule on the ground of substantial compliance or presence of special circumstances or compelling reasons. Number five, the certification against firm shopping must be signed by all the plaintiff or petitioners in a case. Otherwise, those who did not sign will be dropped as parties to the case under reasonable or justifiable circumstances. However, as when all the plaintiff or petitioners share common interest and invoke a common cause of action or defense, the signature of only one of them in the certification against firm shopping substantially complies with the rule. Finally, the certification against firm shopping must be executed by the party pleader, not by his counsel. If, however, for reasonable or justifiable reasons, the party pleader is unable to sign, he must execute a special power of attorney designating his counsel of record to sign on his behalf. Jacinto versus Gumaru. What are the contents of a pleading stating a party's claim or defense? Every pleading stating a party's claims or defenses shall, in addition to those mandated by Section 2, Rule 7, state the following. Names of witnesses who will be presented to prove a party's claim or defense, summary of the witnesses' intended testimonies, provided that the judicial affidavits of said witnesses shall be attached to the pleading and form an integral part thereof. Only witnesses whose judicial affidavits are attached to the pleading shall be presented by the parties during trial, except if a party presents meritorious reasons as basis for the admission of additional witnesses. No other witness or affidavit shall be heard or admitted by the court, and finally, documentary and object evidence in support of the allegations contained in the pleading. Section 6, Rule 7, emphasis supplied. Explain the purpose and significance of Section 6, Rule 7. Section 6, Rule 7 is intended to expedite the trial of cases by compelling the parties to be ready with their testimonial evidence before they file their pleadings stating their claims or defenses. That is, all pleadings except the reply and the rejoinder. It provides that such pleadings shall state the memes or names of witnesses who will be presented to prove a party's claim or defense. A summary of the witness says intended testimonies provided that the judicial affidavits of said witnesses shall be attached to the pleading and form an integral part thereof. Only witnesses whose judicial affidavits are attached to the pleading shall be presented by the parties during trial, except if a party presents meritorious reasons as basis for the admission of additional witnesses. No other witness or affidavit shall be heard or admitted by the court. Examples of meritorious reasons are: 1. The witness is an adverse, hostile, or unwilling witness. Number 2. Despite the exercise of due diligence, the proponent could not have discovered the witness or procured his judicial affidavit prior to the filing of the pleading. Number 3. Testimony of a witness on rebuttal. Note that the preclusive effect does not apply to documentary and object evidence. The reason could be that it would already be imposing undue hardship on the pleader if he is also required to be ready with such evidence at the time of the filing of the pleading. That ends Rule 7. Coming up, Rule 8, and if you're not yet subscribed to our channel, go ahead and hit that subscribe button and let's study together. If you have some documents, the most recent one, please send me an email, send me a copy so I can read it. Thanks.